Good afternoon, ladies and gentlemen. Let me first remind that you need to be served a printout to cover this class discussion. I might miss to get noticed in the last class. The rest of constitutional discussion has been available in my mailbox located on the 6th floor of the law building. Please populate the common rooms for recovery of the printout. Okay, how was your Chuseok holidays? Many of the students will probably be happy with your family members. It is heard that the days were critical in time for the presidential campaign. Have you exchanged the communication about the coming election? It is truly trendy about this election that now nobody can match a bet who would be the next president. For the couple of weeks ahead, we would explore the basics of criminal law in the common law context. If you're a lay person, the first on your head would probably be about the criminal law when you're asked to state the typical of laws. Is it not wrong if we are mostly impressed with the criminal penalty and crimes as related with our common sense of legal affairs? It will also be true with the law school applicants and the first-year law students. That intuition would not be incorrect that it constitutes one core of first-year classes as without the essentials of constitutional contract, torts, and real property. Okay. You now view the Hammer Code enshrined in the Louvre Museum. It is considered one of all remnants identifiable as historic implications. The criminal law in its origin can be traced back as far as 2,500 years, both in West and Oriental context. You may know the Hammer Code commanding the lawfulness of retribution. It dictates a punishment corresponding to the perpetrated crime that represents common sense of justice at that time, which is still powerful in the modern minds also. The criminal law probably the most antedated area of laws other than constitutional, civil, commercial laws, not to mention the modern type of administrative or procedural laws. The law has long been indispensable beyond the characteristics of a specific society. This means that the criminal law operates universally, regardless if the society is capitalistic, feudal, or other mode of production or undemocratic one. Of course, the ancient type of criminal law would be as simple and authoritative as in the case of Hammurabi, which could also be found in 8 maxims of ancient Korea and 10th commandment of Moses. For the modern discourse of criminal laws, we need to know that one of the greatest concerns of the democratic revolution perhaps would be how to disrupt the long arbitrary abuse of criminal powers by the dictatorship. It is not surprising to see the portion of a constitutional problems are related with the criminal procedure issues. We could plainly find this context in articles and amendments of United States Constitution, which now is followed by many of democratic constitutional states. Ex post facto laws, privileges against self-incrimination, prohibition of bill of attainder, warrant for a search and seizure, a constitutional dismantlement of cruel and unusual punishment, and so forth. Those speak for the essentials of criminal interest as affiliated with the discourse of modern constitutional democracy. Now, I would like to talk about the practical experiences that the students of criminal law in various jurisdictions encounter in the class. That is of some help to orienteering their minds before entering the details of criminal case laws or court interpretive works. You can see the picture portraying the monthly conference of North Korean Research Circle, South Korea. If we view the criminal justice system in terms of its legal tradition, it will be enabled in tripartite perspectives, which includes common law, civil law, and socialist legal tradition, as exemplified in this case. As you see, the socialist legal system would fairly differ that the political hierarchy would be supreme, governing the legal branches. The Marxist Leninism is revered as absolute to overwhelm a basic assumption of legal system underlying the civilized capitalistic society. The judicial independence could possibly overhaul in the name of popular will of working class, which would be politically and institutionally represented by the Communist Party. The judiciary is subject to the corresponding body of People's Assembly, that the decision has to be finally authorized by that body. Normally, the body of People's Assembly defers to the decision of court, but in rare cases involving the matter of a critical political interest, the decision of court can no longer be effective from the command of with direction from the political institutions. The court officer from the Communist Party could in some cases intervene to prioritize the criminals, notwithstanding the normal process of investigation, prosecution, trial, or execution by ordinary branch of government and judiciary. In many other contexts, the criminal justice system of socialist countries could be considered as distinctive from its two counterparts. The next picture portrays the class of criminal law in civil law country. Our vast of time would be consumed in it. In civil law countries, the criminal justice system is heavily relied on interpretive work of a criminal code, which is of course a prime tool of analysis and provides a vast of discourse in the lecture rooms. It begins with the general part of criminal law, which which deals with the scope of application, mens rea provision, conspiracy, accomplice, self-defense, intoxication, and other causes for exoneration, and so forth. The other class of a criminal law normally followed one or two terms later from the general part would concern each element of various crimes prescribed beforehand in the Korean Criminal Code by the legislators. The crimes stipulated in the code would cover in order by chapter basis that corresponds to the set of criminal values the nation intends to defend against. There will be a stereotype of criminal law discourse in many of civil law jurisdictions, including Korea. A little kind of professor might induce some of hyperbole questions like the death penalty issues or philosophy of criminal sanction that wages a sophisticated interaction between the students and lecturers. You may be aware that they could find no settled viewpoint about the goals of a criminal sanction, whether it would be for retribution, prevention, or correction of criminals, or any mixed ones. Then, how about the criminal law of its counterpart, which will be tasked with us for the weeks ahead? The third picture shows a logo of American Law Institute. It is so small that you may have difficulty in identifying it. The institute is a prime responsibility on uniform state laws and research on development of U.S. laws. It enacted the Model Penal Code, keenly related with the following lectures. The discourse would be virtually same, covering the general theory of criminal law, followed by the analysis of each element of crimes, typically incorporated in various jurisdictions of the United States. The difference would lie in the legal tradition itself, which means that the source of law exists in the form of case laws. The case law only has a binding effect in the United States, which is also true in the criminal law context. Of course, the grand theory of no punishment without no prescribed code, long upheld since the advent of a modern state, should also apply to the U.S. case. This vindicates the most common of crimes have effectively been merged and incorporated by the penal code of each state jurisdiction. Typically, catch-all provision normally works to incorporate all common law crimes within a specific jurisdiction. Therefore, you can note that the U.S. courts exercising criminal jurisdiction would more usually involve an interpretation work of criminal statute to resolve the criminal case than a contract or a tort cases. This point would perhaps result in that the latter area of laws could be more typically attributed as common laws to the lawyers of a civil law tradition, like us. And one of other points need to be drawn that the model penal code would offer a variable touchstone in view of legislative and educational purpose. As of diversity across the jurisdictions, the model penal code prepared by American Law Institute was to cultivate the state legislature. The document also very effectively serves educational purpose by providing the paradigmatic sample of penal code. Within the U.S. federal scheme, the criminal authority is almost exclusively vested in each state, except where a limited scope of federal crimes actually are enacted in the federal statute for the purpose to protect the federal interest. The bifurcation also involves the analysis of U.S. Constitution to delineate a proper criminal jurisdiction between the federal and state government. You may hear about FBI, a Federal Bureau of Investigation, or sheriff, which could be understood in this framework. Later, we will briefly survey the basic process of U.S. criminal justice system, beginning with the investigation, grand jury indictment, trial through execution. In the next example, you can see the summary titled Objectives of Criminal Law. It represents a general recognition, slightly varying with a particular culture involved. The element would be on a retribution, deterrence, in a capacitation, rehabilitation, and lastly, a restitution. Criminal law is distinctive for the uniquely serious potential consequences or sanctions for failure to abide by its rules. Every crime is composed of criminal elements. Capital punishment may be imposed in some jurisdictions for the most serious crimes. Physical or corporal punishment may be imposed, such as whipping, caning. Although these punishments are prohibited in much of the world. Individuals may be incarcerated in prison or jail in a variety of conditions, depending on the jurisdiction. Confinement may be a solitary. Length of incarceration may vary from a day to life. Government supervision may be imposed, including house arrest, and convicts may be required to conform to particularized guidelines as part of parole or probation regimen. Fines also may be imposed, seizing money or property from a person convicted of crime. As I've said, 5 objectives are widely accepted for enforcement of criminal law by a punishment, which include retribution, deterrence, incapacitation, rehabilitation, and restitution. Of course, jurisdiction may differ on the value to be placed on each. Let's see the first objective, retribution. Criminals ought to suffer in some way. This is the most widely seen goal. Criminals have taken improper advantage or inflicted unfair detriment upon others, and consequently, the criminal law will put criminals at some unpleasant disadvantage to balance the scales. People submit to the law to receive the right not to be murdered, and if people contravene these laws, they surrender the rights granted to them by the law. Thus, one who murders may be executed himself. A related theory includes the idea of overriding the violence. So it is one of the most antedated goals generally recognized in a criminal law discourse. And it also corresponds to the case of a hammer of coal. And the second element would be a deterrence. Individual deterrence is aimed to the specific offender. The aim is to impose a sufficient penalty to discourage the offender from criminal behavior. General deterrence aims at society at large by imposing a penalty on those who commit offenses. Other individuals are discouraged from committing those offenses. So generally, the criminal law purpose to impose some imagery about a fear that could evolve some deterrence effect in the potentially criminal person. And the third objective would be incapacitation. Designed simply to keep criminals away from society so that the public is protected from their misconduct. This is often achieved through prison sentences today. The death penalty or banishment have served the same purpose. And fourthly, we can see a rehabilitation as one of objective, and transforming an offender into a valuable member of society. Its primary goal is to prevent further offense by convicting the offender that the conduct was wrong. Finally, we can see restitution as one of objectives. This is a victim-oriented theory of punishment. The goal is to repair through state authority any hurt inflicted on the victim by the offender. For example, one who embezzles will be required to repay the amount improperly acquired. Restitution is commonly combined with other main goals of criminal justice and is closely related to concepts in the civil law, that is to say, returning the victim to his original position. Many laws are enforced by threat of criminal punishment, and the particulars may vary widely from place to place. The entire universe of criminal law is too vast to intelligently catalog. Nevertheless, those 5 strands of objectives are generally recognized, notwithstanding the jurisdictions. Next item shows the elements of criminal law generally held in most of jurisdictions worldwide. It includes actus reus, mens rea, causation, and strict liability. The criminal law generally prohibits some desirable acts. Thus, proof of a crime requires proof of some act. Scholars label this the requirement of actus reus, or guilty act. Some crimes, particularly modern or regulatory offenses, require no more, and they are known as strict liability offenses. One of the examples would be the Road Traffic Act 1988. It is a strict liability offense to drive a vehicle with an alcohol concentration above the prescribed limit. Nevertheless, because of the potentially severe consequences of a criminal conviction, judges at common law also saw proof of an intent to do some bad thing, the mens rea, or guilty mind. As crimes of which both actus reus and mens rea are requirements, judges have concluded that the elements must be present at precisely the same moment, and it is not enough that they occur sequentially at different times. Let's see the first element, then actus reus. Actus reus is Latin for guilty act and is the physical element of committing a crime. It may be accomplished by an action, by threat of action, exceptionally by an omission to act, which is a legal duty to act. For example, the act of A striking B might suffice, or parents' failure to give food to a young child also may provide actus reus for crime. Where the actus reus is a failure to act, there must be a duty of care. The duty can arise through a contract, a voluntary undertaking, a blood relation with whom one lives, and occasionally through one's official position. Duty also can arise from one's own creation of a dangerous situation. On the other hand, it was held in the United Kingdom that a switching off the life support of someone in a persistent vegetative state is an omission to act and not criminal. Since discontinuation of power is not a voluntary act, not grossly negligent, and as in the patient's best interest, no crime takes place. In this case, it was held that since a previous patient could not give or withhold consent to medical treatment, it was reasonable for them to conclude the treatment was not in the patient's best interest and should therefore be stopped when there was no prospect of improvement. It was never lawful to take active steps to cause or accelerate deaths, although in certain circumstances it was lawful to withhold life-sustaining treatment, including feeding, without which the patient would die. An actus reus may be nullified by an absence of causation. For example, a crime involves harm to a person. The person's action must be the but-for cause and proximate cause of the harm. More than one cause exists, the act must have more than a slight or trifling link to the harm. Causation is not broken simply because the victim is particularly vulnerable. This is known as the Sin's-Core rule. However, it may be broken by an intervening act of a third party, the victim's own conduct, or another unpredictable event. A mistake in medical treatment typically will not sever the chain unless the mistakes are in themselves potent in causing death. Let's say the second element of mens rea. Mens rea is another Latin phrase meaning guilty mind. This is the mental element of the crime. A guilty mind means an intention to commit some wrongful act. Intention And criminal law is separate from a person's motive. Although motive does not exist in a Scottish law. A lower threshold of mens rea is satisfied with when a defendant recognizes an act as dangerous but decides to commit it anyway. This is recklessness. It is the mental state of mind of the person at the time the act was committed. For instance, if she tears a gas meter from a wall to get the money inside and knows this will let a flammable gas escape into neighbor's house, he could be liable for poisoning. Courts often consider whether the act did recognize the danger, or alternatively ought to have recognized the risk. Of course, a requirement only that one ought to have recognized the danger is tantamount to erasing intent as a requirement. In this way, the importance of mens rea has been reduced in some areas of criminal law, but it obviously is still an important part in the criminal system. Wrongfulness of intent also may vary the seriousness of an offense and possibly reduce the punishment, but this is not always the case. A killing committed with a specific intent to kill or with conscious recognition that death or serious bodily harm will result would be murder, whereas a killing effected by reckless acts lacking such actually harm through a defendant's actions. The doctrine of transferred malice means, for instance, that if a man intends to strike a person with his belt, but the belt bounces off and hits another, mens rea is transferred from the intended target to the person who actually was struck. You can see a more complicated feature of a common law, a mental state, in the purpose of a criminal law. In contrast to the common law elements, the civil jurisdiction usually recognize two basic forms of mental state, which includes the intent and negligence. In some exceptional cases, a higher level of negligence would be required to constitute a specific crime. And lastly, we have to talk about a strict liability in the criminal context. The strict liability is considered in terms of a civil context, but it also pertains to criminal law discourse. Strict liability can be described as criminal liability, notwithstanding the mens rea or intent by the defendant. Not all crimes require specific intent, and the threshold of culpability required may be reduced. For example, it might be sufficient to show that the defendant acted negligently rather than intentionally or recklessly. In offenses of absolute liability other than the prohibited act, it may not be necessary to show the act was intentional. Generally, crimes must include an intentional act, and intent is an element that must be proved in order to find the crime occurred. The idea of a strict liability crime is an oxymoron. The few exceptions are not true crimes at all, but are administrative regulations and civil penalties created by a statute, such as crimes against the traffic or highway code. The next item shows the cases on actus reus. I've included a list of British cases to give you a basic understanding of an actus reus requirement. And the first two cases, titled R versus Quick, decided in 1973, and Leicester versus Pearson, decided in 1955, involves the voluntariness of actus reus requirement. In R versus Quick, the court held the defendant, a diabetic, was charged with assaulting his victim. The assault occurred whilst the defendant was in a state of hypoglycemia, low blood sugar level due to an excess of insulin. The court held that the defendant should have been acquitted on the ground of automatism. His unconscious state had been the result of external factors, the taking of insulin. In Leicester versus Pearson, the court held a car driver was prosecuted for failing to give precedence to a pedestrian on a zebra crossing, but was acquitted when it was established that his car had been pushed onto the crossing by another car hitting from behind. In the next two cases, the court dealt with the issue on a state of affairs involving actus reus dispute. In R versus Lansonier, decided in 1933, the court held that the defendant was convicted. The court held that the prosecution had proved the facts necessary for conviction, and the Court of Appeal dismissed the defendant's appeal on the simple basis. In that case, the defendant was a French national who had entered the UK lawfully, but was given only limited permission to remain in the country. At the end of the period, the defendant left England, not to return to France, but to travel to the Irish Free State. The Irish authorities made a deportation order against her, and she was forcibly removed from Ireland and returned to the United Kingdom. On arrival in England, the defendant charged under the Aliens Order 1920 with being found in the United Kingdom, whereas not having permission to enter the country. On this count, the defendant was convicted. An appeal on the ground that the return to the United Kingdom had not been of her own free will, and that she had been forcibly taken to England by the immigration authorities. The Court of Appeal found that conviction of defendant has to be sustained. In Ninja case decided in 1983, the defendant had been admitted to hospital on a stretcher. Upon examination, he was found to be drunk and was told to leave. Later, he was found in a corridor of the hospital, and the police were called to remove him. The police officers took the defendant outside on the roadway, then placed him in a police car and drove him to the police station, where he was charged with being found drunk in a public highway. The defendant was convicted and appealed on the ground that he had not been on the public road of his own volition, so the actus reus requirement arises in this context. The division court upheld the conviction, holding that all that was required for liability was that the defendant should be perceived to be drunk whilst on a public highway. There was no need for the court to have any regard as to how he came to be there. In the next many cases, the case involved omissions in the context of an actus reus analysis. In Greener versus DPP, decided in 1996, the defendant was the owner of a young, powerful structural bull terrier. He left the dog chained in an enclosure in his back garden. The dog has trained and bent the clip releasing its chain. It escaped from the enclosure and entered the nearby garden, where it bit the face of a young child. Section 3 of the Dangerous Dogs Act, enacted in 1991, provides that if the owner of the dog allows it to enter a place which is not a public place, but where it is not permitted to be, and while it is there, it injures any person, he is guilty of an offense. It was held by the division court that an offense under section 3 could be committed by omission. The word allows include taking and omitting to take a positive step. In the present case, the defendant had failed to take adequate precaution. Similar precautions have been taken in the past, but they were obviously inadequate, as the fastening was not good enough and the clothes were not secure. And in R versus Diane, decided in 1979, a uniformed police officer saw a man who was being kicked to death. He took no steps to intervene and drove away when it was over. He was convicted of the common law offense of misconduct in a public office, as he had neglected to act to protect the victim or apprehend the victim. This context would be also frequented in Korean cases. In 1992, the court decided R versus Toll and Davidson. The defendants, who were common law husband and wife, were of low intelligence. One day, they were visited by a sister family and took her in providing her with a bed following weeks, she became ill. She did not eat properly, developed bad sores, and eventually died of blood poisoning as a result of infection. The defendants had not obtained any medical assistance for Funny, although they had known that she was unwell. The defendants were convicted of manslaughter. The Court of Appeal held that the defendants had been under common law duty to care for Fanny. This duty had arisen from their voluntarily assuming the responsibility for looking after her, knowing that she was relying on them. The defendant's failure to discharge this duty was the cause of the victim's death. Therefore, in the cases about omission, there's to be some of a legal ground to impose a duty of care. In 1983, the court decided R versus Miller. The defendant had been squatting in a house and fell asleep on a mattress smoking a cigarette. The defendant was awoken by the flames, but instead of putting the fire out, he simply got up and went into another room where he found another mattress and went back to sleep. Very odd person indeed. As a result, the house was substantially damaged by fire, and the defendant was convicted of criminal damage. The House of Lords held that once the defendant awoke and realized what had happened, he came under responsibility to limit the harmful effects of the fire. The defendant's failure to discharge this responsibility provided the basis for the imposition of liability. In the last two cases, the court gave us a basic lesson about a causation as related with actus reus requirement. In R versus White, decided in 1910, the defendant put a potassium cyanide into drink for his mother with intent to murder her. She was found dead shortly afterwards with a glass 3/4 full beside her. The medical evidence showed that she had died not of poison but of heart failure. The defendant was acquitted of murder and convicted of an attempt to murder. Although the consequence which the defendant intended occurred, he did not cause it to occur, and there was no actus reus of murder, according to the court opinion. And we have a very famous case about this area of law, R versus Smith, decided in 1959. Now let's see in more details in our case. In this case, the defendant was involved in a fight with a fellow soldier during which he stabbed the victim, resulting in the victim being taken to the medical station, who died about 1 hour later. On being charged with murder, the defendant argued that the chain of causation between the stabbing and the death had been broken by the way in which the victim had been treated. In particular, the fact that the victim had been drugged twice, first being carried to the medical station. And the medical officer, who was dealing with a series of emergencies, did not realize the serious extent of the wounds, and say the treatment he gave him was thoroughly bad and might well have affected its chances of recovery. The defendant was convicted of murder and appealed unsuccessfully. The court held that the defendant's stabbing was the operating and substantial cause of the victim's death. In this case, the victim clearly died from loss of blood caused by the stab wounds inflicted by the defendant. Finally, I'd like to add some of briefs about a strict liability. A strict liability is an interesting concept in criminal justice system. In some crimes, there is guilty act, which has an identified consequence, but the defendant did not know about or intend for the consequence. Despite this lack of guilty mind, liability is said to be strict to the guilty act, and this crime has been committed without mens rea being present in all the elements of the actus reus. It's a difficult concept to grasp, and the best way to do is to look at some criminal case law. People often make the mistake of saying that the strict liability is a crime absent of mens rea. But in fact, complete absence is extremely rare. Where an offense requires no mens rea and the actus reus will not be voluntary, the crime is said to be one of absolute liability. It is more common that mens rea is missing for one element of the actus reus. There is a presumption in court that mens rea is required, and this was demonstrated in the case of Sweet versus Porter, decided in 1969. When a landlady was found not guilty on appeal of being concerned in the management of premises at which a cannabis was smoked. It was found that since she could not reasonably prevent the smoking of a cannabis or be shown to be aware of it, that there was no mens rea, and that this was not a crime of a strict liability. If a defense successfully rebuilds mens rea, then the only opportunity for the prosecution is to establish that it is a crime of a strict liability. This is the most commonly achieved in regulatory offenses and public danger offenses. Regulatory offenses, such as those governing some aspects of employment law, usually have small penalties, and having them strict liability makes it easier to enforce them. Public danger offenses are another example of this, and the case of Steele in 1993 provides a good example. The defendant was found guilty of possession of a firearm, even though he claimed that he did not know what it was. Given the risk to public safety, the firearms pose such crime are those of a strict liability. The imposition of a strict liability is flexible and varies from case to case. However, it is more likely to be imposed given a certain types of crimes: dangerous drugs, road traffic offenses, sexual offenses, pollution, and sale of food. For example, in the case of Marriott, decided in 1971, he was found to have possession of a penknife with traces of prohibited drug on it. The court stated that whilst mens rea was required for possession of the penknife, no such hurdle was required for proving that the defendant knew or should reasonably have known what the substance was. We can see from case history that strict liability is an important concept in law, which lawyers and courts can turn to in order to protect the public from danger. However, it is a controversial standard as some people consider it contrary to the principle of human rights, and it seems unjust to penalize those who have taken care not to engage in criminal activity. The best way to get comfortable with the concept is to consider the case law. Some 4 examples would be followed in later classes about the United States context. And the next page shows the typical state procedure and federal procedure about the criminal process. This is a substantive criminal law class, but it is indispensable to understand the brief of a criminal justice system, including procedural aspects. The study of criminal law normally includes the examination of specific crimes and defenses, as well as other aspects of a substantive law issues. But the procedures to apply sanctions against those who commit crime is also important in many aspects. These 2 areas of criminal law are normally studied separately in law school, as the cases studied in substantive courses all involve some procedural considerations. I would like to stress a brief overview of criminal justice system is critical even in the course of a substantive criminal law. Largely due to the overriding mandates of the United States Constitution, the procedural rules of each state and federal government are similar. Still, important variations exist which should not be forgotten, even if beyond the scope of this brief overview. In typical state procedure, we can have a 16 stages, starting with the offense through a sentencing and post-trial motions. First, we have to find an offense in order to initiate a state procedure. The criminal justice system reacts to criminal conduct. The process begins with an offense. The process begins when an offense is reported to the police. The investigators get the evidence, testimonial, tangible or otherwise, with the objective of determining who perpetrated the crime. One significant procedure problem that frequently arises at this stage is that of searches and seizures. And second, we can see an arrest. Once sufficient evidence is gathered, constitute a probable cause that an identified person committed a crime, the suspect may be arrested with or without a warrant, depending on the circumstances. The arresting officer takes the suspect in custody and brings him or her to the police station. In the next step, the charge would be imposed. The police ask the district attorney to make out a formal charge and an affidavit, which is a written complaint charging the accused with a specified crime or crimes. A complaint is prepared in advance when a person is arrested under warrant because it is used to obtain the warrant. In 4 states, we can identify proceedings before a magistrate. After charge, the accused is then taken before the committing magistrate, a municipal court judge, for example, who advises the accused of a rights and sends her back to jail or allows her to postpone. If the charge is a misdemeanor, the accused is immediately arraigned and must plead to the charge. If the charge is a felony, the accused normally does not have to plead. Instead, a date is set for a preliminary hearing. In 5th stage, you can see a preliminary hearing. When a felony charge, the accused is entitled to preliminary hearing to determine whether there are sufficient grounds to bind the accused for trial. If there is sufficient evidence, the committing magistrate rules on next step. If critical evidence is pressed for some reason at this point, then the accused may be set free and the charge dismissed. The accused has a chance to cross-examine the prosecution's evidence, which is an important discovery technique. If the committing magistrate finds that the evidence is sufficient, the accused is committed. If the magistrate finds sufficient evidence, the accused may bring a writ of prohibition to appeal the magistrate's findings. In that stage, the indictment was the process. As an alternative, the prosecution may seek an indictment without preliminary hearing. The prosecuting attorney presents a written accusation to an investigative body, such as a grand jury. An indictment is simply a finding made by the grand jury that there is sufficient evidence to warrant a conviction of the crime. The grand jury indictment may either precede or follow arrest. The prosecution may choose the indictment procedure when it wants to keep its information confidential, because in most cases, the accused does not have the opportunity to appeal or to challenge the prosecution's evidence. In a 7th, we can see an accusatory pleading. The prosecution of the case commences once the government files either an indictment or an information. An information is simply the written charge on which the accused will be tried. Once the pleading is filed, the accused is brought before the court and informed of the charge. The accused then pleads to the charge. we can call this process as an arraignment. The accused is normally permitted to make certain motions or one of several pleas. The accused may file a demurrer or a challenge to the legal sufficiency of the accusatory pleading, such as that the court lacks jurisdiction or that no crime is alleged. Other motions include ones to quash or set aside the indictment or information, to dismiss, for a change of venue to another court, for discovery, or to suppress certain evidence. If the charges hold up after consideration of the motions, the accused may plead guilty, not guilty, or no contender, which is the same as pleading guilty, except that the conviction cannot be used in subsequent civil proceedings. Normally, both sides continue the fact-finding process to prepare for trial. The parties use the discovery process to find out as much as possible about the opposition's case. The accused may file certain extraordinary risks before trial begins. The writ of prohibition is an appeal to high court to terminate the judicial process, normally on the basis of a lack of proper jurisdiction in the lower court. The other writ in common use is that of habeas corpus, which means bring forth the body, and which tests any restraint that is contrary to fundamental law, such as any restraint that is contrary to the state constitution. Numerous procedural issues arise during the trial process, including the following: the competence of the accused to stand the trial, as well as the sanity of the accused at the time of offense, and the accused's right to counsel, the right trial by jury and the selection of jurors, the right to fair trial, the accused and the witness privilege against self-incrimination, including the accused's right not to testify as a witness at all, the right to compulsive process to a witness, and the right to confront accusers and cross-examine witnesses. Issues relating to trial of two or more accused in the same to more than one trial of the same accused for the same criminal act, and to the trial of the same accused for more than one crime arising from the same act. Evidence questions relating to the introduction or order of evidence, burden of proof, motions, jury instructions, and so forth. And finally, the verdict, the sentence, and the entry of judgment by the court. This kind of various issues could be disputed in the trial process. Then finally, we can face the sentencing stage. Ordinarily, the judge has substantial discretion in determining the appropriate sentence, as well as a maximum sentence for a particular offense. Typically, the accused who has been convicted may assert several post-trial motions, including a motion to vacate because the judgment was based on erroneous facts or was obtained by fraud or deceit, and a motion for a new trial. Most states grant a forced appeal from a criminal conviction as a matter of right. Other appeals may also be available. you need to know that the writ of habeas is available at any stage of criminal process because the habeas corpus involves a fundamental laws pertinent to the basic human rights safeguarded by state or federal constitution. And as I've said, the federal procedure would be similar to the typical state procedure. In many respects, federal criminal procedure resembles state procedure. In fact, the federal rules of evidence and federal rules of criminal procedure have served as models for state procedure. A few significant rules include the following. First, you can see an arrest. A warrant may be issued on presentation of complaint by the United States Attorney, identifying the crime and the accused. A valid arrest may also be made without warrant where there is a probable cause. Remember that only federal crimes are prosecuted in the federal system. If the accused was arrested without warrant, then a complaint is prepared. If a warrant was used, the complaint was previously prepared. The accused is next brought before a United States magistrate. This must be done without unnecessary delay, as provided by Federal Laws of Criminal Procedure, 5th A. Then preliminary examinations are also held before the magistrate. And the next stage of grand jury indictment. If a grand jury has returned an indictment against the accused, he is not entitled to a preliminary examination, except the federal law of a criminal procedure, 5th C provides that if a person is taken into custody before the indictment is given, he is entitled to a preliminary examination. This avoids the problem of a lengthy holding of a defendant waiting for a grand jury. And the accused is arraigned in federal district court. And in the federal rule on criminal procedure 12, the motion to dismiss is used in place of all other motions discussed above on the state procedure. This motion attacks all possible defects. Now we begin with the discussion of United States criminal law. We are forced to review the sources of a criminal law. Each of the three branches of government has an important role to play criminal justice system. Essentially, the legislature enacts the law, the executive enforces it, and the courts apply it in a particular cases. These roles are not always completely distinct, however, especially because the courts are responsible for interpreting a statute. The four sources of law may be found in a statute law. Most criminal law matters are governed by statute at both the state and federal level. A formal accusation normally contains a reference to the specific law allegedly violated. Whenever an issue of guilt arises, it is most important to examine the specific statutory basis for the criminal charge. And secondly, we can illustrate a common law as one of a source of law in the United States. Just as in most other areas of American law, most modern criminal law in the United States founded in concepts of the English common law. Even though the criminal law is highly codified, the common law provides definitions and examples the courts use to interpret criminal statutes. And finally, the model penal code is one of a great reference in terms of a source of law context. Like other major legal disciplines, criminal law has no restatement. The model penal code has been drafted by a distinguished group of experts in criminal law with a view towards simplification, standardization, structure, and clarity. It has been the foundation for reform in about half of the states and has influenced the development of the common law. We now have a similar brief about a culpability, including actus reus, mens rea, strict liability, in the context of a United States case. To appreciate the problems inherent in interpreting criminal statutes, it is necessary to understand the basic concepts of culpability. Specific crimes are defined by a listing of the separate elements which the state must prove to obtain a conviction. Most crimes require both an actus reus and mens rea terms, meaning that the guilty act must be combined with a guilty mind. Courts commonly refer to this concept as culpability. The first element, actus reus, is required to find a valid crime in the criminal purpose. An accused must have committed a criminal act in order to be convicted. The law does not punish souls that are not acted out. The actus reus normally consists of a prohibited, affirmative, or physical act, such as a breaking and entering for burglary, but it may consist of an omission when there is a duty to act, such as a failure to file a tax return. The act must be conscious and volitional. For example, sleep movements would not be considered acts for purposes of the criminal law. As the second element, mens rea is required. Most crimes require a criminal state of mind, or mens rea. Traditionally, this requirement was satisfied by one of three states of mind: general intent, or the volitional doing of the prohibited act, Second, a specific intent, which requires some intent to do something more than merely the prescribed act. And thirdly, a criminal negligence, which involves a gross breach of a duty of care. These concepts are often described by the terms malice and willfulness. Lastly, we need to consider a strict liability in the context of a criminal culpability. The criminal statutes do not require any particular state of mind. These are primarily regulatory offenses that impose a relatively light penalty and do not involve a direct infringement of another person's rights. Although statutory rape has long been recognized as a strict liability offense. When you study the culpability in the context of the United States, we normally are exposed to a complex nature of a various mental states. Therefore, we have to marshal those complex elements in the context of a model penal code provision. The model penal code replaces the traditional classifications of mens rea with an approach aiming at different levels of qualities of state of mind. This consists of a purpose or intent to cause a result. Second, knowledge or awareness of the practical certainty of a result. So recklessness or awareness of a substantial and unjustifiable risk. And fourth, negligence, where the person should have been aware of a substantial and unjustifiable risk. In interpreting the criminal statute, the court need to look into a legislative intent in some cases. The typical case in dealing with this issue would be a State versus Palindrome decided in 1942. This is a case from a state of New Jersey. Let's see the fact pattern of this case. A Palindrome who was defendant was indicted for an atrocious assault and battery, threatening to kill, and being a common score. The third count was severed by the court on its own motion and briefed and argued by the counsel. State, of course, who plaintiff in this case, argued the state statute provides the nuisances and all other offenses of an indictable nature, a common law, and not otherwise expressly provided for by statute, are misdemeanors. And the sense a common law, being a common score, was indictable, then it can be indicted on count 3. Defendant argued that if the legislature has provided for such conduct to be a disorderly person's offense, and thus otherwise expressly provided for. And secondly, the count is unconstitutionally vague and therefore unenforceable under the 14th Amendment's due process concept. And thirdly, an attempt to criminally prosecute such conduct as violative of the 14th Amendment's equal protection guarantee. At trial, D was acquitted of the first 2 counts. Then the court faced the issue if the common law crime of being a common score is still an indictable offense. It is a common law crime, but may be effectively merged by the catch-all provision of the statute provided by a state legislature. The court said no. Each of these contentions is meritorious. According to the court opinion, we can find a gist of holdings through this passage. As late as the 1890s, being a common code was criminal conduct in New Jersey. However, by 1890, such conduct had not been criminal in England for years. The legislature has encompassed such conduct in the present Disorderly Persons Act. The legislature has never, in almost 200 years of a statehood, addressed itself to the offense. There is no indication that being a common code is any longer a crime. The common law is dynamic, adapting to the requirements of a current society. Current society has evolved away from the common code offense. And due process requires that laws give persons of ordinary intelligence reasonable opportunity to know what is prohibited so the person can avoid the defense. Laws, in order to prohibit arbitrary enforcement, must provide explicit standards for those who apply them. If a vague statute abutting upon First Amendment freedoms inhibits the exercise of free freedom, it must be ruled unconstitutional. Such is the case here. Here, the legislature has failed to recognize the offense. All an ordinary person has to guide him is catch-all statute and vague offense. This is constitutionally impermissible. A common law, only a woman could be a common code. This discrimination between the sexes is obvious and violative of equal protection. This case shows the problem with criminal catch-all statutes, as well as how courts turn to legislature for guidance. Common law incorporation statutes are in effect in most statutes, in most states. And also you can see the due process concept would operate to safeguard the basic rules evolved in the modern era of a contemporary state. For example, no punishment without a prescribed provision could possibly be implied in a due process concept in the United States context. And the case called a Killer versus Prequel, decided in 1970, showed how to construe the legislative terms in the criminal case. Let's see the fact exposed in this case. A homicide is the unlawful killing of a human being. In the common law, a human being did not exist until it was born alive, and thus the killing of a fetus, a common law, would not subject the actor to homicide charge. Killer, who was a defendant in this case, divorced his wife, not knowing that she was pregnant by another at the time. He later saw his ex-wife on the road, and after noticing that she was pregnant, said he would stomp it out of you. He beat her, causing a miscarriage in which the baby was born dead. At the preliminary hearing, the defendant claimed that the murder statute in California do not cover the death of a fetus, but only a human being or a baby born alive. How do you perceive a fetus as a person in terms of a criminal purpose? Is a fetus a human being and hence capable of being murdered? The court finds negatively, and the court ordered the writ should issue. The second meaning of the term human being as used in the statute is a person born alive. Thus, Defendants Act is not covered by the current statute. All crimes in California are codified. There are no common law crimes. Due process prevents retroactive application of a penal statute, even if the court had the power to rule that a fetus is a human being. Of course, dissenting opinion asserted that medicine now makes it possible for most viable fetuses to be born alive. Therefore, the court should see that the fact should be taken into account in interpreting the statute. Because the unknown caused by this case, the California statute will change it to include the killing of a fetus as a subject of murder charge. This case points out the complex interaction between the three branches of government. And as we have learned in the criminal law class of this law school, there could we find a comparing principles between two major legal traditions when the court undertakes the interpretive work of a criminal statute. Let's see, the rule of a strict construction applies to the cases of a criminal nature. Strict construction of criminal statutes arose in the 18th century as a means of saving minor offenders from the death penalty. And the court has to keep on the rule or plain meaning of a statute. Statute language that is plain and admits of no more than one meaning does not allow the court to exercise its power of interpretation. This plain language rule is more fundamentally important when the court involves the criminal cases. And one of the rules on interpretive work would be about resolving ambiguity. A legislature must never attempt to define the specific result that its legislation should engender in a particular case. In fact, the broad language and ambiguity may be politically essential to obtain passage of a legislation. Therefore, the work to resolve ambiguity is critical in the context of criminal cases. And the rule, long held, is through a various jurisdiction, it would be as justum generis, where general words follow the enumeration of specific things. The justum generis rule interprets the general words to apply to the to the same general class or nature as the specified items. This doctrine was ascertained in the case of McCoy versus United States, decided in 1931. Therefore, a statute, for illustration, defining motor vehicle to include a motor vehicle, truck, automobile wagon, a motorcycle, or any other self-propelled vehicle not designed for running on rails, have not to extend to airplanes. Those are a different class in the definition of the criminal statute. And the rule on explosive units as exclusive authorities would also be one of the guides when the court engaged in interpretation of a criminal statute. This maxim states that the expression of one thing is the exclusion of another. Hence, an arson statute that was amended to include one type of motor vehicle, a trailer coach, implied that other motor vehicles were not within the statute. This rule was held in the case P vs. Nicholas, decided in 1970. And in Paul Mortier is also one of other doctrines concerning the construction of criminal statute. A statute importing material must be construed together. Thus, if one offense defined by a statute specifies a particular intent and another in the same way does not, that intent cannot be implied in the other. This rule was ascertained in the case State versus Bradley, decided in 1973 in the state of Kansas. And federal statutes are generally enacted under the power of the necessary and proper clause. State statutes are based on the state police power. Under the supremacy clause, a state statute will be invalid if it has been preempted by federal legislation in the same field. There may be some role of administrative agencies in enacting the criminal statute. A legislature may delegate to an administrative agency the power to make rules which are enforced by criminal penalties set by statute. But such delegation is proper only if the legislature set forth sufficient standards in its delegation statute to guide the administrative agency. Lastly, I have to give you a brief about constitutional limitations in the context of a criminal law. While constitutional issues are more frequently raised as objections to procedural aspects of criminal law, certain constitutional values are implicated by substantive criminal law. Personal sexual practices have been subject to criminal sanctions which raise constitutional defenses. The due process clauses of the 5th and 14th Amendment prohibit convictions for an offense that is too vague. In other words, insufficiently precise as to the persons and conduct within its scope and the punishment that can be exacted for its violation. The degree of certainty required of a criminal statute depends upon a number of factors, including the extent to which statute terms can be made more precise without creating loopholes whether flexible language is necessary to enforcement of the statute, and whether a particularly important interest, such as free speech, is endangered by the lack of precision. In part, the requirement of precision serves to assure the persons potentially subject to statute will have advance warning as to whether the conduct is criminal. Thus, a statute is unconstitutionally vague if it fails to give a person of ordinary intelligence fair notice that a contemplated conduct is forbidden by the statute. In addition, the statute must be sufficiently certain so that courts will have adequate guidance when called upon to enforce them. Accordingly, a statute will leave judges and jurors free to decide without any fixed standard what is made criminal is unconstitutionally vague. Statute precision is also directed at curbing abuse by law enforcement officials. Therefore, statutes which are so worded as to place unfettered discretion in the hands of the police are void of vagueness. A statute which would otherwise be unconstitutionally vague may be upheld if it requires that the prohibited act be committed with scienter or intent. The theory often urged is that the scienter element satisfies the fair warning purposes of the void for vagueness doctrine. And that will be all for the first class of criminal law. And I now stop here.